Welcome to the last panel of this international conference on North Korean human rights. My name is Janet Anderson. I've come here today from The Hague, which, as many of you may know, is a centre for courts, tribunals, justice and accountability. Maybe a little bit of a narrow judicial approach occasionally in The Hague, so it's very exciting and interesting to be here, where we're also discussing some of the political aspects as well. Congratulations to the organisers for such rich, varied, interesting voices that we've had during this morning from North Korea, from South Korea and beyond. I'd like to point out that we have a panel here of all women, also rich and varied, leaders in their fields, and to echo one of our previous speakers, if I'm saying your name correctly, Vija, Herefos, or Via, as you would say in Dutch, it is important to have a gender dimension and to ask where the women's voices are and to make sure that you have people who will look also as women themselves in certain areas. They all represent innovative approaches. They have all got points, possible pressure points that we can look at and to discuss together when it comes to North Korea human rights. We'll be looking at ideas for engaging states on the prevention of atrocity crimes, ideas of new legal avenues that could be explored for accountability, leveraging the potential of data-driven evidence gathering and incorporating sanctions as ways of responding to human rights violations. The last panel was challenges. This is meant to be opportunities. So let's leave here with a good feeling, we hope. But I'm sure that we will be talking about some of the challenges as well. So I will introduce each of the speakers as they start. And our first speaker is Nancy Yu, the Deputy Executive Director of HURIDOCS, an international NGO that helps human rights groups gather, organise and use information to create positive change in the world. She has a very full bio. Please make sure that you have a look in the programme to see more about her. And she has a presentation. So we're going from this general approach, and we'll be going down and down along our panel towards sanctions in the end. Over to you, Nancy.
Are we speaking from the podium?
No, we're speaking from the
Perfect. Very good afternoon to you all. I'm very honored to be here. Thank you for the invitation, particularly to Korea Future, who invited us and speak at length about their work with HURIDOCS. I'm also very honored to be here with this distinguished panel because I think I'm a bit of a fish out of the water here. I work much more with data than in these speaking panels. But I have to say that human rights defenders need evidence and law and research in order to achieve and advocate for justice and accountability. And at HURIDOCS, we develop tools and strategies to make this information accessible. The North Korea Religious Freedom Database and the North Korea prison database, which we heard about this morning, demonstrate just how very possible it is to systematize a large amount of complex material and expose human rights violations without revealing the identity of survivors and keeping the integrity of other related but private information. Technology in this case enables the data to be organized and presented in order to reach a wider audience, but all credit sincerely goes to the investigators for their meticulous work in interviewing and capturing the most important bits in a way that is digestible for human processing. So I'm going to be brief. Defending human rights in the digital age doesn't come with risks, doesn't come without risks and challenges, however. So what are some of these? I'm just going to go through really quickly so that we'll have much more time with opportunities and also for Q&A. Collecting too much information. That's, for example, the wrong type of information or without expressed consent. Sometimes it's the right kind of information, but not properly formatted to use in the future. Acquiring information from distant or not reachable locations and/or restrictive environments, often arriving delayed and sent later on when it's safe to send across, or in chunks, but possibly incomplete. Analyzing troves of data and curating relationships between between entities takes considerable amounts of time. And I want to underscore that it takes considerable amounts of time, and this is the long journey towards justice. And then, of course, there's data storage and preservation of evidence for an indefinite, sometimes indefinite amount of time, and there are costs involved with that. Information security is also an ongoing challenge. And defending sophisticated attacks and system vulnerabilities in technology is probably the biggest thing that we have to handle as software developers, and there's always new tactics. So and there's also increased volumes of user-generated evidence, and that is videos and photos taken on handheld devices and establishing provenance or authenticity of material. As well as verification of data and putting into place trusted timestamping mechanisms or protections against doctoring of information, whether that be intentional or unintentional. So design of databases is not always the sexiest topic to discuss, but it is something that is very much a challenge and the foundation of how we do this work for future accountability. So on to what are the opportunities ahead. This is not all technology-based, but it does hinge on technology as a platform to be able to facilitate the information sharing of it. So one really key component of our work is in strengthening the knowledge within the human rights community around protocols and guidelines for collecting and recording open source. But this also can include closed source information. So that they can be used in future prosecutions at the national and international levels. At HURIDOCS in particular, we are interested in co-creating tech tools with human rights defenders to ideate and implement new and existing features designed with and for the needs of the community. So the best example of this is that the satellite imagery that was brought into the database platform, which at HURIDOCS is called a WASI, was in large part due to Korea Future's interest in being able to geolocate the information at the penal facilities in North Korea, which they could not access. I also want to commend that the 3D modeling work that they did with in partnership with another group. It shows the tremendous possibility of being able to use technology for good and to demonstrate that it is possible to document human rights violations in a way which is exposes the problem in a conscious and compassionate way. And I think that's amazing and really, really incredible work from Korea Future there. As well, sharpening advanced search and filtering analysis tools is an ongoing need of human rights defenders, not specifically to North Korea per se, but I think that it goes without saying that those abilities and databases built for accountability is essential. But of course, leveling the playing field for concentrated efforts to localize databases is also important because I think that there's a strong emphasis in software these days that does not open up access to other communities who are language proficient or have language are not native language speakers, and therefore they don't have tools that are as robust for the purpose. So again, to be able to present a database in multiple languages as Korea Future has done in Korean and English is incredible. So a few more. Refining user permissions in databases allow for greater collaboration while simultaneously protecting access to specific data. This we've heard over and over and over again, to be able to collaborate with other lawyers or prosecutors. They definitely want to show some elements of the data, but not all of it. So this is in design of databases that's quite complex that I won't go into. I'll spare you the details. And then a few other challenges and then opportunities that we have ahead are to harden infrastructure, as well as invest in storage for the long term. And that, as for us as software developers, means that we need to find cheaper but secure options for archiving the evidence, because oftentimes it may not be touched for a long time, and it needs to be protected in a way where it can be used in the future. And last but not least, there's some interoperability opportunities with open source tools used by other tool developers and human rights defenders in this space. And I think that means that we share our resources. Interoperability is really key to be able to do data exchange, and documenters need a way to capture and authenticate and send information more efficiently. Last but not least, there's a lot of innovation happening now in the technology space with cryptographic techniques and decentralized web protocols to meet technical and ethical challenges of establishing trust in this digital records. And also at HURIDOCS, we explore using automated information extraction through machine learning advances to dramatically cut down the time spent in data entry. And this is something that I think is very cutting edge, but is possible with natural language processing. And it will enable investigators to focus more of their time in actually pursuing the justice. And so I'm being really quick because I think that I wanted to demonstrate that, in short, building tech for the public interest implies putting as much of the data controls and input into the hands of the main administrators and curators, not the software developers. I want to underscore this because if they need to come back to us over and over again, we do not have the capacity to be able to sustain that. What we're interested in is building tools to be able to have them empowered to be able to use their database for the long haul. So whether it is in North Korea, Ukraine, Myanmar, or any other difficult context, we see that technology combined with sound human rights documentation is a winning combination to seek future justice. And I'll stop there.
Great, thank you so much, Nancy. It's now my pleasure to invite Catriona Murdoch, a partner with Global Rights Compliance, an international criminal and human rights lawyer, and with her very specific expertise on the crime of starvation and associated starvation violations and right to food abuses. Catriona.
Thank you. Good afternoon, everybody, and thank you again to Korea Future for hosting this really important event at a somewhat turbulent time. I'm sure most of you are checking your phones at the moment, but hopefully we can still have a bit of interest on this important event as well. I also want to thank my panelists and to Janet for your elegant moderation as ever.
Let's hope.
As Janet said, so my area of work is on international criminal law and the intersection between justice and accountability. I'd like to focus on two challenges and then two opportunities as well. I think the first challenge, and it will come as no surprise for most of you, is securing any form of justice and accountability in the North Korean context. I think in this space it can be a very tricky concept to grasp. Opportunities for seeking redress for the egregious and continuing human rights violations and atrocities really do seem quite riddled with obstacles. And I think this in turn leads to a real inertia by the international community. Global Rights Compliance, the organisation that I work with in the context of a project with the National Endowment for Democracy Fund, have produced an accountability strategy report where we've mapped a number of different pathways, international and national, to see what options there may be for organisations like Korea Future, looking at the merits and the challenges of each of those options. Now, one of the pathways that I think has been talked about for some time now, and indeed has been advocated by Honourable Lord Alton, is a referral to the ICC. As GRC is an organisation based in The Hague, working in and out of the courts and tribunals, of course, this was something of interest to us. I think the voices supporting this pathway have multiplied since the findings of the UN Commission of Inquiry, but the current challenges of actioning this pursuit, again, remain quite fraught. The primary challenges, I think, for many of you will be familiar. The first is, of course, North Korea is not a state party to the Rome Statute. The second is a Security Council that is very much stalled and unlikely to make any referral in the immediate future. This leaves one option, which is for the prosecutor to open an investigation on her own merits, on his own merits now, for cross-border crimes that have been committed partly in the territory of North Korea and partly in state parties, using what is known as the Bangladesh and Myanmar precedent, something which we as an organisation were actively involved in relation to the Rohingyas. Now, of course, I think the consistent collection of documentation proving the occurrence of these cross-border crimes is absolutely imperative. And again, organisations like KF, using the tools like Nancy has outlined with HURIDOCS, is something that really needs to be invested and supported. And I think that the UK in its current role, particularly with the Human Rights Council, could really actively contribute to this initiative, particularly through support to organisations who do such important and, in many instances, perilous documentation work. So because of this challenge, this was sort of, it laid down the gauntlet a little bit for us to try and work out, okay, well, if that's not an option, as international criminal law practitioners, what is, and what can we do in this space? We've looked at a number of different innovative pathways, and one of which emerged during our research was a novel pathway that hadn't been explored before. And that was whether pursuing a route through the International Court of Justice through the prism of the Convention on the Elimination of Discrimination Against Women might be an option, also known as CEDAW. So what did this opportunity entail? I'll try and distill that in a few moments. It's a quasi-accountability option. Essentially, the way that it would work would be it would focus on the power of the General Assembly to submit a request for an advisory opinion to the ICJ for matters within the scope of the Charter that would fall within the Assembly's competences. One of the aims of the UN, as many of you will be aware, is to establish conditions with respect to the obligations under international treaties and international law, and also for the maintenance of peace and security. A referral to the ICJ could be interpreted as an effort by the General Assembly to create such conditions. And so there are numerous UN reports with credible documentation collected again by organisations like Korea Future and others to suggest that the DPRK, despite its partial engagement with CEDAW, is not respecting its obligations and therefore is in violation of international law. Notwithstanding this as an opportunity, I think there's still some practical challenges here. The first is that the pursuit can only be realised if a resolution is passed by half or more of the General Assembly. So we need a number of about 97 for a simple majority. This likely puts this option into a long-term pursuit rather than something that's going to happen in the next year or so. The other slight limitation to this route is that it's not a criminal pursuit as such, and so it's less victim-centred. There would be no reparations in that sense, and victims and survivors would be less actively involved, which of course is a challenge. But again, I think this is something that the UK could support, and again, it would align with their principles at the Human Rights Council to continue its work against ending violence against women and girls. And we have seen the General Assembly, who have been active in recent months and trying to bypass a stalled Security Council in relation to Ukraine. The situation in North Korea unequivocally amounts to a threat to international peace and security. And I think this is an issue that the US, the UK, and a number of other member states have called for, and of course has been evidenced in the last few weeks with some of the recent provocations on the peninsula itself. So turning then to the second challenge, and this is one that I personally have really grappled with in the work that we've done as an organisation, and that's making an impact. I think that the biggest challenge, as I say personally, has been the scale of violations we're looking at here and the utterly dystopic nature of this regime. I think when I have engaged with stakeholders, whether it's UN-based or whether it's bilateral negotiations or discussions with states, often it feels that this is a problem that is too big, it's too complex, it's, where would you make an impact and where would you even begin? Coupled with this are the limited accountability options, as I've said. So one approach that we've looked at is to try and focus on finding a hook. And as Janet mentioned, one of the areas of my expertise is right to food violations and starvation. And I think, as Nancy mentioned as well, Career Future certainly have an edge in trying to find these novel approaches and doing so in a, as you say, in a conscious and compassionate way. One of the ways that GRC, Global Rights Compliance, and KF have looked at is the use of penal starvation, and whether in both the political and the ordinary prisoner system there is a use of starvation that appears to be systematically and deliberately used as a method of torture. And you saw some of the 3D modelling there. Now, nearly a decade has passed since the Commission of Inquiry reports where its recommendations in terms of access to penal facilities and access to the camps by external monitors continues to be blocked. And there has been no focused investigation at all into the use of deliberate starvation. So herein lay the opportunity. Because of the targeted and fairly contained nature of penal starvation, it is an optimal entry point for re-energising focus around some of these recommendations at a time where the North Korean human rights community begins to coalesce around this 10-year anniversary. If this was put at the forefront of international agenda, it could really highlight the broad treatment and withholding of a number of different aspects, whether that's healthcare, for example. It could also lead to an improvement on humanitarian access, an issue that is already garnering significant attention, again, at Security Council level and Human Rights Council level. And again, the issue of food deprivations has been something that the new Special Rapporteur for DPRK has mentioned in her latest report. So again, I think there is an opportunity here with a niche area to provide governments, international organisations and humanitarian actors with an entry point here. And in preparation for this, I think the documentation collected by organisations like Career Future could really support that humanitarian angle as well. The importance of the preservation of this information, as Nancy has said, is absolutely critical. So I think in conclusion, there is plenty of dystopic darkness in this space, but I think there is also a lot of hope. And I think with organisations like Career Future and some of the others on this panel, I think we all have a real clear opportunity to act. Thank you.
Thank you, Catriona. Our next panellist is Dr. Kate Ferguson, the Co-Executive Director of Protection Approaches, which she co-founded in 2014 to transform how identity-based violence is understood and transform how it is prevented. Kate.
Thank you so much. What a very weird time to be on a panel in Parliament. Maybe we can kind of take a moment to kind of, especially those of us that work in and out of this place, it can feel so often like it's the centre of the world. It's never true. And whatever comes out of this fallout, what we're talking about now, and the prevention of mass atrocities anyway, that has to be central. And so that is just a constant of whatever happens in and out of number 10. But thank you for being here and kind of not having your phones immediately in your faces. Like, that is no mean feat or ask. Thank you too to our co-hosts. What a really rich day it has been, and I've certainly learned so much. Particular thanks to Career Future, partly for the seamless organising and patience with me when I was terrible at getting back to you, but also for the extraordinary work that you're doing. I mean, I am so continually impressed by the work that you put out, and yet it always looks so beautiful, which human rights work very rarely does when it's presented, let's be honest. We often cut those corners. I also have a caveat before I start talking. I am really an imposter in this space. I am no expert on North Korea or North Korean human rights. Any expertise I have, such as they are, relates to the prediction, prevention, and response to mass atrocity crimes. So crimes against humanity, genocide, ethnic cleansing, and war crimes. And even within that bracket of violence, identity-based atrocity crimes, so particularly crimes against humanity, where there is a sort of manipulation of identity involved, ethnic cleansing, crimes against humanity. It has been very humbling to be in this space, particularly hearing the extraordinary testimony of kind of violence, torture, struggle, and resistance. But my remarks today are going to talk about what structures can do, and particularly because we're here in the UK Parliament, what the UK government can do. And think about maybe that challenge we've just heard of how do you have impact in a situation that is really quite so challenging and dreadful as North Korea. So first of all, let's start off with kind of what is atrocity prevention. At its simplest, it is a means of making decisions where you are centering how best to prevent further loss of life or escalation that can lead to those crimes occurring or occurrence of those crimes. So even in a situation such as North Korea, where these crimes have been endemic in the system of the politics and governance of the country for so long, it is an approach that says further violence can still be prevented. Maybe not immediately, but there are still things that can be done and decisions that can be taken where that violence becomes less likely, or perhaps an easier way of thinking about it is you're making it more difficult to take place. You're inhibiting that violence. In policy terms, particularly if we think on the state level, so we take the UK as an example, but by no means does this responsibility only fall on UK shoulders. First of all, you need political will and leadership. You need there to be a kind of appetite to do something. That on its own, though, is never enough. You need the expertise that are really around where these kinds of crimes, this kind of violence, this pathology of violence that is very different to armed conflict, that is very different to other forms of mass violence, where it comes from. You need to have systems that monitor and assess that violence, its risks, where it comes from. And we have heard this afternoon and this morning such extraordinary examples of how that information is collected, and whether that is personal testimony, whether that is through big data, whether that is through painstaking legal efforts. We have the data. We know what's happening, even in a situation that is so very, very closed. So you also then need to have the kind of systems in place to communicate risk. Because even if you are that country team, how are you then supposed to respond? You need to have the means of communicating out, both within your own government, but then also within the multilateral system, perhaps with regional partners, certainly with civil society allies. You need to have those mechanisms in place so you can kind of do something with your assessments of that data. But even then, when you're able to communicate that risk, and to some degree with North Korea that is happening. We are here, for example. I don't think anyone, whether in the UK, the US or elsewhere, charged with looking at violations in North Korea feels that they don't know that these risks are high, have been, the violence is taking place. So what we need then is a playbook of what the UK government in this instance could do differently to make that violence less likely, more difficult to take place. And so that's what I'm going to focus on now, sort of how do you get to a playbook with a country and a system of governance and a system of violence that is so very closed and so very entrenched. All instances of modern mass atrocity crimes require an architecture of violence that enable the implementation of those crimes to take place. And these vary, the shape and size and peculiarities of these architectures of violence vary from, if we look at Russia today, will look very different to North Korea. There are certain trends, though, that you can break down. There's always a political architecture in place, even in a very small geographic instance, for example, ISIS in Iraq and Syria, right? There was a political architecture there. There is an armed architecture and a violent architecture that is responsible for the sharp end of the violence. Very often the foot soldiers of mass atrocity crimes are really quite some way away from the chief architects that are designing, implementing and commanding the overall policies of violence. There are very often structures of communications, state and increasingly non-state platforms that justify and legitimize the violence. Because as we've heard today, even in a situation so very, very controlled and closed and authoritarian as North Korea, the regime has to have some kind of control over the information. It needs to legitimize what it is doing in the eyes of its publics and to a certain degree in the international publics. That is the same for practically all chief architects of atrocity crimes. They have and rely on these systems. So if we map those networks out and we can find those kind of nodules of influence, of connection, where you're seeing transactions and relationships that are making that violence easier. Even with the instance of North Korea, those relationships are very often transnational. They can be targeted from outside of the boundaries of that country. Then suddenly, confronting these crimes, and this is not to say it is easy, we are actually then faced with a raft, a spectrum of policy options that can be taken. Doesn't mean they will be, because of course we need the expertise, the systems to identify them, and the political leadership. But there are those opportunities for influence, leverage, and sanction that can be taken that can make that violence more difficult to take place, and for a state like the UK to have a more consistent approach. None of this is meant to say as if this is a silver bullet, but these are tools with which we can kind of follow through. Before I end, I just want to draw attention to something that happened in Parliament at the beginning of this week, on a more positive note to the kind of more chaotic scenes that we saw last night. Sarah Champion, who is the chair of the International Development Committee, released a report on the UK's approach to atrocity prevention. And it was my great privilege to serve as their specialist advisor for the duration of that inquiry. I cannot speak for the committee, and at no point have I ever been able to do that. But I am probably biased when I say that I'm really very pleased with that report. But I urge all of you to have a look at that report, because what it has done, it doesn't focus on North Korea, it actually makes no country-specific recommendations, but it calls for this networked approach to prevention to be central in the UK's approach to atrocity crimes. Because it is very easy to say that we in the UK have a responsibility to help protect people from these crimes, or to stand up against them, or that they're abhorrent and never again should they take place. They have always taken place, and just looking at the impacts of climate change alone, they will become more likely unless we radically, as a global society, learn to confront them. It also calls for a national strategy on atrocity prevention. And again, this points to the need to centre this commitment, not only in the country teams that are responsible, or the thematic teams of sanctions, or the thematic teams that are working in the, via the United Nations or Geneva through the international justice mechanisms, to bring a cohesiveness to that approach. It calls also for mandated training for ambassadors, heads of mission, their team, so they can really have an understanding of what these crimes are, where they come from, how they are distinct from conflict prevention, which has for so long determined the UK's approach to mass violence overseas. And North Korea, more than any other instance, illustrates that mass atrocity crimes have a different root than armed conflict. Now, the UK government is doing some of this, right? They have an atrocity prevention hub. They are looking at how they can support country teams in this sphere. If we weren't in such current political flux, I might even feel more optimistic. But whatever happens in number 10, and whatever happens in the next couple of weeks, this growing consensus within Parliament, across civil society, cross-party, that atrocity prevention must be central in the UK's international policy, I think is something very actionable that all of us can take forward and strive towards that challenge of making impact. It's only moving the dial, and that is not to kind of raise expectations, but it is really something that I think could help us do something different with regards to North Korea. Thank you.
Great, thank you, Kate, for also situating that against the background that I refuse to refer to, but now everybody knows. Sorry, it's important too. I'm not checking my phone. No, not really. And last speaker on the panel is Megan Smith from REDRESS, where she leads their work on the use of the Magnitsky sanctions to provide accountability for serious human rights violations. Go ahead, please.
Thanks very much. First, I just want to echo everyone's thanks and admiration for Korea Future, for the APPG on North Korea, and for everyone who's spoken and moderated today at this fantastic and much needed event. I'm going to be talking about Magnitsky sanctions, in other words, targeted sanctions, so sanctions on individuals and entities rather than countrywide sanctions, which are imposed in response to serious human rights violations and also corruption. Many of you may already be aware of this, but they are called Magnitsky sanctions in honor of Sergei Magnitsky, who was a Russian tax lawyer who, after uncovering a massive Russian tax fraud scheme, was detained and then died in police custody. His friends and colleagues campaigned after that for these sanctions to be introduced, and they are now in some form or another in 12 jurisdictions across the world, including the UK, the US, EU, Canada, and Australia. And one thing I want to emphasise is that this is about individual responsibility and accountability, not a countrywide regime. So I'm going to focus on the UK regime. It was introduced by, I'll talk about human rights specifically as well. The global human rights sanctions regulations were introduced in 2020, and they allow the Foreign Secretary to impose sanctions on both state and non-state actors for their involvement in 3 types of human rights violations: violations of the right to life, the right to be free from torture and cruel, inhumane and degrading treatment, and the right to be free from slavery or forced labour. The Foreign Secretary has to have what's called reasonable grounds to believe that someone is an involved person enabled for them to impose sanctions. One thing I want to pick up on is the definition of involvement. It's defined really broadly in the regulations. So in theory, sanctions can be used to target that really broad range of actors who are involved in gross human rights violations. So like Kate said, it should enable the government to take a network approach to these crimes. So for example, it's not just about the prison officer or guard who tortures an individual detainee. It could also capture those who are responsible for it through a chain of command. It could be those who promote or even finance the violations. It could be those who benefit and profit from them, which is an interesting point, particularly around the issue of slavery and forced labour. They can also apply to those who have obligations to investigate and to prosecute these crimes, but they fail to do so. The decision to impose sanctions, it's important to note, is a policy decision at the end of the day. It's a foreign policy tool. So in addition to these legal tests having to be met, there are a number of policy considerations that the FCDO will take into account. So that may be the severity of the violation. So are they widespread and systematic, which obviously in the case of North Korea, they are, as we've heard. Who are the individuals that they might be wanting to sanction? Are they of a position where it's imposing sanctions could impact on their behaviour and the behaviour of others? Are there other law enforcement mechanisms that could be used instead of sanctions? Again, in the North Korean context, I suggest the answer is no. These sanctions framework was introduced by Dominic Raab, and we saw 105 designations during his time as Foreign Secretary. There has been a real marked slowdown in the UK's use of these sanctions. There were just 3 sanctions, Magnitsky sanctions under Liz Truss, while Foreign Secretary, PM, and now PM. And I think this is just something to bear in mind, but it's CSOs and NGOs are calling for a more active use of Magnitsky sanctions, particularly in relation to the most egregious cases of human rights violations, such as in North Korea. One point to flag is that when these sanctions were introduced, the FCDO envisaged an active role by civil society. They published a policy note which gave guidance to NGOs who might want to provide evidence and identify potential perpetrators for sanctions. We worked with the FCDO to produce a template for submissions and work with human rights activists all over the world to help them prepare evidence files and identify those who may be appropriate targets for sanctions. So just looking at how the UK has approached North Korean human rights sanctions, there have just been 2 sanctions on North Korean entities in relation to human rights violations. That's the Ministry of People's Security Correctional Bureau and the Ministry of State Security Bureau for their involvement in running camps and for their involvement in violations of the right to life, torture and enslavement. I think it's just interesting to compare this to the US, which is by no means perfect. But so the US has sanctioned around 29 individuals and 11 entities for their involvement in human rights violations. And that includes for censorship activities and the detention and forcible return of those who have been able to flee the country. Now, the UK government and the various sanctions ministers have said time and time again that coordination of sanctions is the aim. Sanctions are only effective if they are imposed multilaterally. We haven't seen that put into practice, and I think the North Korean example is a good example of that. And if we really want effective sanctions action, then there has to be coordination at that level, not just talk of it, we have to see it. If a country is out on its own, it can undermine the legitimacy and the impact of these sanctions where they are imposed. I want to touch on impact. It's something that's been mentioned by all of the panelists, and it's something that's really hard in the context of sanctions. First, to address the distinction between targeted sanctions and countrywide sanctions. Many here will know far better than I have the devastating effects that countrywide sanctions can have on countries and has had on people in North Korea, particularly around the provision of aid and the access to scarce resources. The idea of targeted sanctions is to mitigate that negative impact on the population because it's about individual responsibility. But we did see, for example, in Afghanistan, when sanctioned Taliban members became ministers, that blocked the provision of humanitarian aid until an exception was made. So where targeted sanctions are imposed, there still has to be really careful and informed approach to make sure that those who are being sanctioned won't have a negative impact. On the positive side, and now we're gathering evidence of this as a civil society, but there are some really good examples of the impact that targeted sanctions can have. Talk a lot about this one, but Bangladesh is just an example. And I know it's a very different country from North Korea, but I think it's just interesting. So the US imposed sanctions on the Rapid Action Battalion, which is Bangladesh's security force, which was responsible for extrajudicial killings and forced disappearances. After those sanctions, there were no extrajudicial killings and no enforced disappearances for a period of 3 months. Bangladesh came to the negotiation table with the US and agreed to engage with UN representatives. We know from civil society actors on the ground that it created space for civil society to have open conversations about human rights violations where they couldn't before, and prevented a number of people from wanting to join these security forces. There have been some human rights reprisals on human rights defenders, so it's not that clear cut, but it has been one of the most effective international acts of foreign policy in relation to human rights in Bangladesh. Like I said, North Korea is a very different country, and I am not a North Korea expert, but there's a couple of things I just want to flag. Sanctions can be used as an effective tool in the carrot and stick critical engagement approach, which I know is also open to criticism. And it's also important from an accountability perspective. The Foreign Office often talks about behavioural change, and that is such an important purpose. But another purpose in the regulations is accountability. And like Catriona mentioned, in North Korea there are limited opportunities, if no opportunities, for domestic accountability and international accountability. And where they are with these really inventive ideas, which are fascinating, they're long term. sanctions can be imposed rapidly and effectively on individual actors. And for victims and survivors and community groups who at the present have no form of accountability or justice mechanisms, sanctions can, to some extent, they are not perfect, they are not a full form of accountability, but they can fill that gap. It's international recognition of what's happening to people on the ground. It's reinforcement of calls from civil society for accountability and support. And so I think it's something to seriously consider. Just have one last call, I think, and it's an opportunity, so ending on a positive note. It's International Human Rights Day on the 10th of December. This is often used as an opportunity for governments, particularly the US, to reaffirm their commitment to human rights and to impose targeted and well-informed strategic sanctions. My call might be for the FCDO and the government to consider North Korea and actors for their hopeful list for sanctions on Human Rights Day, if anything just to mirror those that have been imposed by the US, to show that there is international coordination and commitment to take action where possible against those who are perpetrating these human rights abuses. Thanks.
So I'm sure you'll agree with me, 4 very interesting presentations there with tons of food for thought and lots of hooks for us to grasp onto, and I hope there will be plenty of questions from you. I hope that we've got a little bit of extra time because we started a little late. Yes, I'm getting a yes from back there. I just wanted to start by reflecting back a little bit, Catriona's point. What was the words you used? Dystopian darkness?
Dystopic darkness.
Dystopic darkness, okay. Rolls off. Against that backdrop, I want to ask all of you a very general question. How can you make a better impact? You've all addressed it partly, but I just want to push you all a little bit further for something a little more. For example, if we take with Megan, what exactly can NGOs do in order to enable the FCDO to do something further on sanctions? You say they should be doing something. What are you doing in order to push them along there? We know that it is difficult to investigate in North Korea. What more can you be doing at HURIDOCS? I mean, I was very intrigued by this idea of long storage and what does that mean? How do you support organisations in that form? I was wondering about how exactly we're going to get a national strategy on atrocity prevention. What's your next stage? You've already done the first part, but what's coming up next? And for you, it's very much just what now? You say, that bit's difficult, that bit's unlikely. What's the very diplomatic term you use? Long term, I think was it? Yes, long term strategies. What about now? So, who would like to go first? Start with you, Megan.
Thanks. Pressure's on. So I think one crucial thing is evidence sharing, and I'm sure there are lots in this room who are already doing that. But like I said, the sanctions regime was set up with CSO's participation in mind, and there is a huge amount of really incredible documentation work that is happening. So I think these incredible open databases is providing that to the FCDO, and organisations like REDRESS can help other organisations and activists do that, packaging it and providing it to the FCDO within the framework of the sanctions regime to demonstrate why this evidence could provide evidence to underpin sanctions designations on individuals and entities. Just to flag one challenge in that is that open source information is generally preferable, but I acknowledge that there is often a need for closed source evidence with personal testimonies, for example, to link perpetrators to individual abuses. There is a lack of clarity at the moment from the FCDO around the receipt of closed source materials because the risk of disclosure if their sanctions designations are challenged. That's something that we're trying to highlight with the FCDO and really have an honest conversation about, because in contexts like North Korea, if they can't receive confidential information without a guarantee that it could be disclosed, that's really precluding the provision of really, really important information that could lead to sanctions and accountability on individuals who might otherwise go undetected. So I think that's something, and using examples like North Korea to show that, I think is really important. So I think there's a proactivity that's required from the civil society, all working together to provide this incredible work and evidence to sanctioning authorities, and help them try and reach decisions that we think would benefit those on the ground.
Nancy, maybe that's a point that you want to pick up.
Yeah, I fully support everything you just said, because I think it's remarkable to see the open database, because it demonstrates just how possible it is to show the evidence and share it widely. At HURIDOCS, we work with a lot of defenders around the world who are capturing information in a private way. And there's a lot of validity and reasons for that. But as you said, with the closed source data, the utility of it sometimes is hard to demonstrate to others that actually this is what's happening on the ground. And on the note of data storage, one of the things in design of databases for the long term is how to capture this, preserve this with a timestamp. And that timestamp is really, 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 really important. And so designing mechanisms to be able to create multiple storages, which has a cost, because if you have very large files, they can weigh down a database quite massively, and then you times that by 2 or 3. But in order to authenticate and ensure that the data is protected for the future without any question, this is important to think about as a long-term strategy that we need to invest in.
So I think my answer would be the continuation of capacity building, and I think for us, Global Rights Compliance as an organisation, having worked in and out of the international courts and tribunals, we often can act as an interface between CSOs and those legal and justice mechanisms. And so I think what's really important is, linking to what you've said, Nancy, is making sure that all of this documentation that is being collected is admissible, how that would work in terms of whether that's litigation, what a prosecutor would say to this, what defence lawyers would be saying to it, how a sanctions regime like the UK would receive that information. And so through capacity building and also, legal reviews of sanctions submissions or information that could be capable of supporting sanctions, I think is absolutely critical, because, with the best will in the world, having all of this, brilliant information, if it's not time-stamped, if it's not, goes through the relevant procedures, it's not going to be actionable. So I think that's something, right now that can be done.
Okay, it's back to your pressure on the government.
I've got 2 for impact via pressure on the government. Is there anyone from the FCDO Korea team here?
Who would like to out themselves?
No. I mean, I don't need to put anyone on the spot. It was just, I don't want to kind of teach people how to do their jobs. It's the opposite of what I want to do. But so first on the atrocity prevention strategy, what next? First of all, anyone into that, come and talk to us. We have been driving calls for this since our inception as an organisation 8 years ago, and we're in such a really very positive place. The FCDO are working so constructively with us and with our partners on this. We coordinate the UK Atrocity Prevention Working Group, which is an amazing consortium of about 25 NGOs, research institutes, experts that really are kind of the experts in their field. And of course, Career Future is a fabulous member of that group. Detmer, my colleague over there, is our coordinator, so you can talk to him about it too. So we probably need to recalibrate a little bit in response to this week's shifts. Because actually Liz Truss, as Foreign Secretary, was very supportive of this work, as the past 5 or 6, I lose count, Foreign Secretaries have been. So it's on an open door there. There is a willingness. It's not a confrontational advocacy ask. This is something that HMG number 10 FCDO have recognised as part of the UK's 2030 strategic objectives. Now, of course, there's so much uncertainty right now. We take nothing for granted. My more targeted one, and this is why I was wondering if there are people in the audience that do work with the Korean country teams. We at Protection Approaches work with a number of UK particular missions and embassies and country teams, both here in Whitehall and then in their country locations. And what we do is we kind of essentially work to map out how an approach to this particular pathology of violence that is very different to armed conflict and therefore requires a different response to conflict prevention can be embedded in what they're doing. And it is a very collaborative, consultative exchange. You know, we are there as those that know about atrocity prevention, but those country teams working at the front line, whether it's in DRC, whether it's Bosnia, you know, extraordinarily important and very challenging work. And it can sometimes be too easy for those of us on the activist side to kind of see where those changes can be made. But I do think that something that could have impact immediately would be to kind of, for us as an organisation, to work more effectively, you know, with the UK representatives that are tasked with looking at these challenges. I think we would almost certainly identify opportunities for coordination, collaboration and kind of leverage that are currently not being identified even. Sometimes it's not that there isn't the desire to do more, it's hard to find the time to map it out. So, you know, you bring us geeks in and we'll help sort it out.
Do you have any questions from the audience? Yes, please.
I'd like to address a question on sanction. Actually, I was in Geneva a few months ago. I met with a number of diplomats at the United Nations. I asked this question: is there any chance or possibility we can fraud North Korean leaders' bank account under that sanction committee? And the United Nations diplomat told me, unless one of the Security Council members to motion of this subject, and that is now passed on to the European Union, otherwise SWIFT itself cannot do anything. Do you think is there any possibility we can fraud? There is one example of in Venezuela, the opposition leader, and he, as one of the Security Council members holding the asset, because we don't give the asset to the dictator, but we will give the future democratic Venezuela. So is it do you think possible at all?
Who of the Security Council is going to step up and hold on to North Korean assets?
I don't think I can speak for the UN Security Council, but I would agree with that assessment that you just explained. I think from the perspective of targeted sanctions, I think it's a really good question. So generally, and sorry if I'm telling everyone what they already know, so if the UK imposes sanctions, that means any assets in the UK jurisdiction that belong to that person will be frozen and they're not allowed to come into the UK. So in a case like that, so say for example, you know that there is an individual in North Korea and someone outside of that jurisdiction holds assets for them, say in the UK, let's just hypothetically, or the US for example. It is possible under the sanctions regimes for sanctioning authorities to sanction those who are associated with people who are involved in sanctionable activities. So you could argue that, okay, this person who holds assets for X perpetrator in North Korea is associated with him. It could be, or her, it could be that they are helping them to conceal the profits of sanctionable activities or just their assets to evade sanctions. So that would be possible in the breadth of the regulations. It's not really been done so much. We've seen in relation to Russia, the UK has used that associated with criteria to impose sanctions on family members who likely have assets that are from the profits of those individuals involved in corruption or etc. So in theory it is possible, yes, and I think it's something that we would advocate for because it again goes to Kate's point around the network approach. It's not just about targeting those who are directly involved, but it's about enablers and facilitators and those who help conceal evidence and ill-gotten gains. Because without those, a regime like that would potentially fall apart. So I think it's a good question. I think it's something that should definitely be pursued. And if you have information on assets linked to those within the jurisdiction within North Korea, I think it's definitely something to raise and something that Redress would be really happy to talk to you about.
Okay. Yes, one at the back.
So we've talked a lot about North Korea, but one of the things we haven't talked much about is China, and particularly China's practice of repatriating people who flee from North Korea. Does anyone on the panel know of any countries which have sanctioned China over this practice, or steps taken by the international community to tackle it?
I actually don't off the top of my head, but it's a really good question. And I think if any jurisdiction has done that, it's most likely to be the US. But I don't know, but it's something I can check and I can get back to you. But yeah, it's a good point. And I think thinking about it from that perspective too, like taking a much broader approach to different actors and countries who are involved in these violations and all the different pressure points is 100% the right way to be thinking about it.
And I think I know from a US policy perspective, I'm same as Megan, I'm not sure if sanctions have been discussed or issued, but certainly from a policy perspective, there's an increasing interest from the US to look at how to leverage or target China as a means with which to move the dial, if I can put it that way, on the North.
I mean, and in addition, right, bringing it back to the UK context, we were expecting there to be some kind of development of a UK-China strategy, which has sort of so far been this hole in UK foreign policy. And it's exactly that kind of question that you're posing needs to be redressed in that, you know, and there needs to be some kind of striving for consistency in how the UK can confront Chinese state role in cross-border facilitation, and then also, of course, the complicity and implementation of atrocity crimes on its own soil. And so really speaks to actually the overlap between what that China policy must be, and then also whatever that policy on how the UK approaches atrocity crimes generally, actually. So it's a really important question.
Do I have time to ask one more question? Or not? Well, it's a very general question, but it's picking up Via's presentation this morning on gender. I just wanted to ask all four of you how far you place a gender lens on your work and recognise maybe some of the gaps that we have, because it may be more difficult for us to find evidence of something like sexual and gender-based crimes, or because, you know, just where is gender in your work? Nancy?
Well, in the tool landscape, gender is very imbalanced, but I would say that it's definitely remarkable to see that the database collection of Career Future has solely focused on the sexual-based violence that's occurred within the penal context, and it is again demonstrates just how possible it is to bring a gender lens to this work, and how important it is to highlight the inequity in our data collection. I think that as sort of a steward of databases, it's definitely unusual, and it is a model for how we could go forward.
Catriona, gender and starvation?
Yeah, so certainly with starvation, I think the next year of our work with two other organisations in the North Korean human rights space will be focusing exclusively on women and girls. The Special Rapporteur's mandate and the upcoming report of hers in March will focus on women and girls. So certainly for us, it is something that we're looking at very carefully. I think the data side of information and testimony and documentation on girls and children in particular is less. There's less of it for a number of obvious reasons. But again, I think I would defer, you know, as Nancy said, to KF's database, which has a huge amount of information on just how women are persecuted, discriminated, and violated in a number of ways.
Gender and sanctions?
We're currently doing some multi-jurisdictional analysis on this, so I can't give a definitive answer, but I do think there is a general initial sense that female victims of human rights violations are underrepresented as a victim group within sanctions. I had a quick look on this on the UK sanctions list, and out of hundreds of sanctions, about 20, I can't remember the exact number, relate to some form of sexual violence. And understandably, as you alluded to, sexual violence, gender-based violence is one of the more difficult human rights violations to document, and I think that really comes into that. But again, my call would be the provision of evidence where we have it and the documentation to the government. And the government has a focus on sexual and gender-based violence at the moment with the Prevention of Sexual Violence Initiative coming up in November. So it should be something that the UK government is looking very closely at.
I imagine with identity politics, atrocity
all the
prevention.
time.
Yeah.
I mean, atrocity crimes impact all genders very distinctly, and that has to be central in any approach to their kind of prediction, prevention and response. In addition to that, there's a real need to understand the compounding risks that face anyone who is perceived to be part of a marginalised group, even within a system of acute violence, and whether that is because of their perceived gender, sexuality, political affiliation, their age, whether they're perceived to have a disability or not. They face additional and compounded risks in situations of mass violence, and that is like across the board. That will be happening in North Korea because it's been found to happen everywhere else. So the need to have an inclusive as well as distinct approach to those compound risks. Yes, all genders, but also inclusivity more broadly as well.
Thank you. Well, that wraps up this final panel. I'd just like to say thank you to all the panellists. Ask you to remain seated because there's just going to be a final word to say goodbye. Should we go away, or would you like us to sit down?
You can be here. So, first of all, thank you very much for all the moderators and speakers who are here to share your expertise and insight into North Korean human rights. It was amazing, even for me. So I also thank all the audience for being here. I hope it was an insightful and informative session to learn more about North Korean human rights. The video of this conference will be published in Korea Future's YouTube channel. It will be updated on our Twitter maybe, so please keep an eye on it. For any inquiries, please keep in touch with Korea Future inquiries regarding the conference. But thank you for coming. Thank you all.
Thank you.